Let's go back to Veritas v. Schmidt. I want to read the dissenting opinion, not because I agree with it, but because I want to understand how and why that rationale is applied by certain types of people. And this Morgan Christen is writes the dissent for the opinion. And for people who don't know, and I recall this because I did watch an appeals case down in Portland, there are 3 judges, which is sort of strange because they're all of, good standing enough to be this higher level judge. But so the 2 that sided with Project Veritas, the writer for the prevailing opinion was Judge Sandra Ikuda, and so this dissent is written by the lone dissent of the 3 judges on that panel. So, the Ninth Circuit. So, Christen Circuit Judge dissenting. She puts in a quotation mark. The right to speak and publish does not carry with it unrestrained right to gather information. Zemel v. Rusk, 381 U.S. 1, 1965. When it adopted Oregon Revised Statute Sections 165-540, the Oregon legislature required that notice must be given before in-person oral conversations may be recorded. With this statute, the legislature ensured, that Oregonians would be free to engage in the uninhibited exchange of ideas and information without fear that their words could be broadcast beyond their intended audience, appear on the evening news, or worse, be manipulated and shared across the internet, devoid of relevant context. Project Veritas engages in undercover investigative journalism, and it finds Oregon's protection against the secret recording of oral conversations a hindrance to its operations. Project Veritas seeks a ruling declaring Section 165.5401C unconstitutional, arguing there is no distinction between hearing a conversation and secretly recording it. Because the majority does not dispute that the state has a significant interest in protecting the privacy of Oregonians who engage in conversations without notice that their comments are being recorded, our court's analysis should be straightforward. First, principles of federalism require that we begin from a premise of reluctance to strike down a state statute. Next, following Supreme Court precedent, we should sever the 2 statutory exceptions that Project Veritas challenges, apply intermediate scrutiny to the content-neutral remainder, recognize that the statute is well-tailored to meet Oregon's significant interest, and uphold Section 165.5401C as a reasonable time, place, or manner restriction. The majority takes a very different path. It begins by straining to avoid the conclusion that the 2 exceptions to Section 141C's notice requirement that Project Veritas challenges are severable. From there, the majority concludes that severance is inappropriate by implausibly speculating that the Oregon legislature, which the majority faults for overzealously protecting privacy, would have preferred to jettison all of Sections 541C rather than striking the 2 exceptions. My colleagues do not contest that Oregon has a significant interest in protecting people from unannounced recordings of in-person conversations, but they rewrite the state's articulated purpose. The purpose Oregon advances is a significant interest in protecting participants from having their oral conversations recorded without their knowledge. The majority recasts the state's interest as one in protecting people's conversational privacy from the speech of other individuals. Slip OP at 25, emphasis added. That reframing of the legislature's purpose serves as the springboard for the majority's reliance on the inapplicable line of Supreme Court authority that pertains to state action aimed at protecting people from unwanted commercial or political speech, not protection from speech-gathering activities like Project Veritas's, which are qualitatively different because they appropriate the speech of others. The majority glosses over this important distinction, and in the end, it declares that all of Section 165.5401C is unconstitutional by concluding that the state's ban on unannounced recording leaves no adequate alternative channel of communication. This final rationale is contrary to the reason of our own court, which has explained that hidden mechanical contrivances are not indispensable tools of news gathering. Investigative reporting is an ancient art. Its successful practice long antecedes the invention of miniature cameras and electronic devices. Dietman v. Time Inc., 449 F2D 245249, 9th Circuit, 1971. Because modern technology now allows voice recordings to be manipulated and disseminated worldwide with a few keystrokes and clicks, the protection afforded by Section 165.5401C is more important than ever. For all these reasons, I respectfully dissent. 1. In 1955, the Oregon legislature enacted what is now Section 165.540 of the Oregon Revised Statutes, a wiretapping law that requires the consent of one party before a telecommunication or radio communication may be recorded in Oregon. See State v. Lissy, 747 P2D 345350 1987, Oregon Revised Statute 165.540-1A 1955. The legislature amended 165.540 in 1959 to require that anyone wishing to record an in-person conversation must first specifically inform all participants. Lissy 747 P2D at 350 and N4. The primary concern underlying 165.5401C was the protection of participants in conversations from being recorded without their knowledge. State v. Neff 265 P3D 6266, Oregon Court of Appeals 2011. The 1959 amendment was codified as, Section 165.5401C of the Oregon Revised Statutes, and it is the focus of Project Veritas's appeal. Now I'm going to read footnotes 2. The original wiretapping statute provided in relevant part that a person may not obtain or attempt to obtain the whole of any part of a telecommunication or radio communication to which such person is not a participant by means of any device, contrivance, machine, or apparatus, whether electrical, mechanical, manual, or otherwise, unless consent is given by at least one participant. Oregon Revised Statute 165.540-1A, 1955. This section was later amended to include face-to-face conversations conducted via video conference. Compare Oregon Revised Statute 165.540-6A, 2022 with Oregon Revised Statute 165.540-6A, 2019. My use of the term in-person conversation encompasses the audio portion of conversations conducted by video conference. Okay. Going down page 47, 2 exceptions to Oregon's ban on recording in-person oral conversations are at issue. The first, adopted by the legislature in 1989, allows the unannounced recording of a conversation during a felony that endangers human life. Oregon Revised Statute 165.540-A, 1989. The second exception, adopted in 2015, permits the unannounced recording of a conversation in which a law enforcement officer is a participant, provided that certain conditions are met. Oregon Revised Statute 165.540, 5B 2015. As to this exception, the majority recognizes that our own court has squarely held that the right to record law enforcement officers performing official duties in public is protected by the First Amendment. See Fortitude versus City of Seattle, 55 F3D 436, 439, 9th Circuit, 1995, Askins v. Department of Homeland Security, 899 F3D 1035, 1044, 9th Circuit, 2018. The majority takes the position that the federal law also protects recording during a felony that endangers human life. Assuming the exceptions to Section 541C are indeed coextensive with conduct protected by the federal constitution, the exceptions do not change the speech that is permitted in Oregon. 4. Section 165.5401C provides that no person may obtain or attempt to attain the whole or any part of a conversation by means of any device, contrivance, machine, or apparatus, whether electrical, mechanical, manual, or otherwise, if all participants in the conversation are not specifically informed that their conversation is being obtained. Oregon Revised Statute 165.5401C, 1961. The term conversation is defined to include only oral communications. Oregon Revised Statute 165.53351. Specifically, this is footnote 5. Specifically, the officer must be performing official duties. The recording must be made openly and in plain view. The conversation must be audible to the person by normal unaided hearing, and the person recording must be in a place where the person lawfully may be. Oregon Revised Statute 165.540, 5B. Project Veritas challenges Section 165.5401C's requirement that a participant must give notice before recording an in-person conversation in Oregon. This provision applies to unannounced recordings of conversations, which, as explained, are defined to include only oral communications. Oregon Revised Statute 165.5351 and 165.5401C, emphasis added. Project Veritas proposes to investigate the Oregon Public Records Advocate and Public Records Advisory Council by conducting surreptitious or unannounced recordings of conversations in open areas open to the public, including cafes, parks, and sidewalks. Project Veritas also proposes to investigate violent protests in Portland by secretly recording conversations between police and protesters and secretly recording conversations between its journalists and police. Okay, and then there's 3 and 4. Let's see. I'm going to go back and read the footnote in a second. 3, secretly recording conversations between its journalists and protesters, and 4, openly recording conversations with protesters without providing notice of the recording. The majority repeatedly suggests that Project Veritas seeks to record only in public places, but Project Veritas avers only that most of its recording will occur in public places. It does not identify the other venues that it has in mind. Footnote 6. The majority asserts that Section 165.5401C applies to both audio and video recordings. It supports this statement with the observation that the statute bars individuals from obtaining a conversation by means of any device. Slip up at 6 and note number 3, quoting State v. Copeland, 522 P3D 909 and 911-12, Oregon Court of Appeals, 2022. And the observation that the term conversation is defined to include both in-person oral communications and those conducted via video conference. Neither observation changes that the statute expressly requires notification only before recording an oral communication. A video recording that does not include an accompanying audio recording of an oral communication is not subject to the statute. The majority resists the result of the clear statutory language by arguing Copeland did not differentiate between a video of a heated discussion and a video of a shooting. Slip up at 6, number 3. But the case concerned a video that captured both a conversation and a shooting, and nothing in the opinion implies that Section 165.5401C would apply to a video that did not capture an oral communication. See Copeland 522 P3D at 912-13. All right. Project Veritas, and we're on page 49, acknowledges the validity of Oregon's prohibition on eavesdropping and explicitly disavows any intention of eavesdropping. As Oregon defines that term, this means Project Veritas will not intercept wire or oral communications to which Project Veritas is not a party without the consent of the participants. Oregon Revised Statute 165.5431. Instead, Project Veritas plans to record conversations in which its reporters participate by using concealed recording devices and not giving notice that the conversations are being recorded. Project Veritas argues that such recording is protected speech under the First Amendment and that the other participants in these conversations have only a limited, tenuous, and minimal privacy interest in not having their speech recorded. In defining the scope of the First Amendment protections, Section A, our precedent draws no distinction between the process of creating speech and speech itself. Anderson versus City of Hermosa Beach, 621 F3D 1051, 1061-62, 9th Circuit 2010. We've explained that because the recording process is self-expressive and is inextricably intertwined with the resulting recording, the creation of audiovisual recordings is speech entitled to First Amendment protection as purely expressive activity. Animal Legal Defense Fund versus Wasden, 878 F3D 1184 1204, 9th Circuit 2018, quoting Anderson 621 F3D at 1062, reasoning that the act of creating a recording is itself expressive, much like writing a book or painting a picture. But unlike writing a book or painting a picture, recording a conversation involves the appropriation of other speech. To be clear, I agree that Project Veritas's act of creating a recording is protected speech, but it is important to recognize that the type of speech Project Veritas plans to engage in, unannounced in-person recordings of oral conversations, infringes upon other speakers' competing interest in conversational privacy. That competing interest plays a critical role when we assess whether state's time, place, or manner restriction is reasonable and sufficiently tailored to the state's significant interest. Project Veritas argues that the dangerous felony exception and the law enforcement exception are both content-based, rendering all of Section 165.5401C content-based. For purposes of analysis, I assume this is correct. Content-based restrictions on speech are subject to strict scrutiny. Wasden 878 F3D at 1204, and Oregon does not argue that Section 165.5441C can satisfy that heightened standard. But even assuming that Section 165.5401C fails strict scrutiny, if the two challenged exceptions are considered, the question we should ask next is whether the two statutory exceptions are severable. B. The Supreme Court recently reiterated in Barr versus American Association of Political Consultants, Inc., AAPC 140 S Court 2335/2020, that when confronted with an exception that renders a restriction on speech impermissibly content-based, we apply ordinary severability principles, starting with a strong presumption of severability that dates back to the Marshall Court. ID at 2350, see Free Enterprise Fund versus the Public Account Oversight Bill, BD. 561 US 577 508 2010. The court's presumption of severability allows courts to avoid judicial policymaking or de facto judicial legislation in determining just how much of the remainder of a statute should be invalidated. AAPC 140 S Court at 2351. The presumption of severability applies with particular force where, as here, the legislature added an unconstitutional amendment to a prior law. In those cases, the court has treated the original pre-amendment statute as a valid expression of the legislative intent. ID at 2353, quoting Frost versus some community of Oklahoma. It looks like 278 US 515 526-27 1929. We need not guess at whether the Oregon legislature intended its previously enacted protection for in-person conversations to exist independently, because Section 165.5401C was a freestanding provision for 30 years before the legislature adopted the dangerous felony exception, and it was freestanding for 56 years before the legislature adopted the exception that allows the recording of law enforcement officers performing official duties in public. As the majority points out, the Oregon legislature's statutory scheme is among the nation's strongest protections for conversational privacy. Slip up at 6N1. What the majority overlooks is that this makes it particularly implausible that the legislature intended Oregon's entire conversational privacy statute to be struck down rather than have the two challenged exceptions severed. The majority suggests that it addresses severability only because I rely on it. Slip up at 31, but the Supreme Court has made clear that striking down a statute before considering severability is not an option. Page 52, veritas v. Schmidt, dissenting opinion. We have an obligation to consider severability regardless of whether litigants raise it. Footnote 7. Principles of federalism make it particularly important that we apply a surgical approach in this case and sever any constitutionally suspect provisions. Because we are a federal court treading on a state statute, the majority acknowledges that the severability of a state statutory provision is, of course, a matter of law. Leavitt v. Jane L. 518 U.S. 137139, 1996, per curiam. And both Oregon statutory law and Oregon Supreme Court precedent require us to apply a presumption in favor of severability. See Oregon Revised Statute 174.040, Outdoor Media Dimensions, Inc. versus Department of Transportation 132, P3D 518, Oregon 2006. Specifically, Oregon Revised Statute Section 174.040 provides it shall be considered that the legislative intent in the enactment of any statute that if any part of the statute is held unconstitutional, the remaining part shall remain in force unless the statute provides otherwise. Okay, I'm going to go back and read footnote 7. New York v. United States, 505 U.S. 144186, 1992. Having determined that the take title provision exceeds the powers of Congress, we must consider whether it is severable from the rest of the Act. Emphasis added, according to Accord Brockett v. Spokane Arcades, Inc., 472 U.S. 491, 507, 1985, rejecting Appellee's arguments that appellants had forfeited the severability issue before our circuit, in concluding that our circuit should have considered severability before striking down a state statute. See brief for all appellees at 44 Brockett, 472 U.S. 491, NOS 84-28, 84-143, 1984 WL 565782. At 44, see also National Association for Gun Rights, Inc. versus Mangan, MANGAN 933 F3D 1102, 1122, 9th Circuit 2019, addressing severability sua sponte, even though neither litigant addressed it on appeal or in the district court. So we're back to The Oregon Revised Statutes 174.040, and then it shall be considered, this is about severability, the statute provides otherwise. Point 1, point 2, the remaining parts are so essential and inseparably connected with and dependent upon the unconstitutional part that it is apparent that the remaining parts would not have been enacted without the constitutional part. Or 3, the remaining parts standing alone are incomplete and incapable of being executed according with legislative intent. In outdoor media dimensions, the Oregon Supreme Court explained that ordinarily, when one part of the statute is found unconstitutional, the court's practice and the legislature's stated preference is to sever the offending part and save the remainder of the statute unless the legislature has directed otherwise, unless the parts of the statute are so interconnected that it appears likely that the remaining parts would not have been enacted with the unconstitutional part, or unless the remaining parts are incomplete and cannot be executed in accordance with legislative intent. 132 P3D at 18. None of the Oregon's exceptions to the presumption of severability apply here. So we should sever the 2 exceptions Project Veritas challenges and evaluate the constitutionality of the remaining notice requirement. No one disputes that Section 165.5401C is content neutral if the 2 challenge exceptions are severed, so intermediate scrutiny applies. See Turner Broadcasting Systems, Inc. versus the FCC, 512 U.S. 622, 642, 1994. To survive intermediate scrutiny, a name, place, or manner restriction on speech must be narrowly tailored to serve a significant government interest and leave open ample alternative channels for communication of the information. Ward v. Rock against Racism, 491 U.S. 791, 1989, quoting Clark v. Committee for CMTY for Creative Nonviolence, 468 U.S. 288, 293, 1984. The narrow tailoring requirement does not mean that the government's restriction on speech must be the least restrictive or least intrusive means of serving the state's interest, but the government cannot regulate expression in such a manner that a substantial portion of the burden on speech does not serve to advance its goals. ID at 798 to 99. 1. Oregon's Attorney General argues that Section 165.541C's restriction on recording in-person conversations is justified by Oregon's significant interest in ensuring that Oregonians know whether their conversations are being recorded. This is unquestionably a significant state interest. The Supreme Court has recognized that privacy of communication is an important interest and that restrictions protecting this interest can encourage the uninhibited exchange of ideas and information among private parties. Bartnicki v. Voper, 532 U.S. 514, 532, 2001, citation omitted. The court has also recognize that the fear of public disclosure of private conversations might well have a chilling effect on private speech. ID at 533, according to American Civil Liberties Union of Illinois versus Alvarez, 679 F3D 583 605 7th Circuit 2012. Conversational privacy is easily an important government interest. Project Veritas does not dispute this point. Indeed, it acknowledges that privacy is an important governmental interest that eavesdropping and wiretapping prohibitions are narrowly tailored to protect. Nevertheless, Project Veritas argues that if one of its undercover reporters consents to having an in-person conversation recorded, the other party to the conversation only has a limited or tenuous and minimal privacy interest in not being recorded. To reach this implausible conclusion, Project Veritas begins from the assertion that an audio recording by a party is little more than a more accurate record of what one party is already, in an overwhelming majority of circumstances, entitled to share in a free society. In other words, in Project Veritas's view, having one's oral communication secretly recorded imposes no greater burden on privacy than merely having the same comments heard. Never mind that recorded comments can be forwarded to vast audiences, posted on the internet in perpetuity, selectively edited, presented devoid of context, or manipulated using modern technology. Project Veritas's premise is emphatically wrong. Indeed, we reason. One who invites another to his home or office takes a risk that the visitor may not be what he seems, that the visitor may repeat all he hears and observes when he leaves, but he does not and should not be required to take the risk that what is heard and seen will be transmitted by photograph or recording. or in our modern world in full living color and hi-fi to the public at large or to any segment of it that the visitor may select. A different rule could have a most pernicious effect upon the dignity of man, and it would surely lead to guarded conversations and contact where candor is most valued. 449 F2D at 249. This rationale is not limited to conversations within private residences, nor does Project Veritas represent that it intends to limit its unannounced recordings to public places, despite the majority's suggestion to the contrary. Ironically, Project Veritas argues that audiovisual recordings are uniquely reliable and powerful methods of preserving and disseminating news and information, internal quotation marks and citation omitted, but sees no contradiction in its assertion that turning these uniquely reliable and powerful methods on private conversations poses no threat to privacy. The secret recording of speech is far more destructive to one's privacy than merely having oral communications heard and repeated. Recorded speech can be stored indefinitely, disseminated widely, and viewed repeatedly. In the age of internet and generative artificial intelligence, AI, surreptitious recording of in-person conversations risks massive and ongoing invasions of privacy. Today, anyone can access and learn how to use AI-generated, powered generative adversarial networks to create convincing audio or video deepfakes that make people appear to say or do things they never actually did. With these tools, the only practical constraint on one's ability to produce a deepfake is access to training materials, that is, audio and video of the person to be modeled. Okay, and footnote 8, Robert Chesney and Daniel Citron, Deepfakes in the New Disinformation War, Foreign Affairs, December 11, 2018, with a link to foreignaffairs.com. Okay, see. The importance of the right to have notice before one's oral communications are recorded cannot be overstated because technology now allows recordings to be selectively edited, manipulated, and shared across the internet in a matter of seconds. Project Veritas acknowledges the privacy interest at stake in Oregon's ban on eavesdropping, yet it denies that the same privacy interests are at stake in Oregon's ban on secret recording of in-person conversations. This position is unsupportable. The privacy interest implicated by secret recordings of in-person conversations is grounded in the same concerns as the privacy interest implicated by eavesdropping. In both circumstances, a person's oral communications are shared with an unintended audience, and the speaker loses the ability to knowingly choose to speak or not speak based upon that audience. There is no question that journalists perform a vital role in our society, and their ability to engage in speech is entitled to constitutional protection. But Project Veritas' speech is not the only speech implicated in the issues of this appeal. By striking down Oregon's carefully crafted statute, the court denies Project Veritas' interviewees the opportunity to knowingly choose not to participate in the recordings Project Veritas plans to create. Respectfully, the majority overlooks that secret recordings can incorporate and disseminate oral comments in ways the original speaker did not intend, and that this implicates a principle of autonomy to control one's own speech. See Hurley versus Irish American Gay Lesbian and Bisexual Group of Boston, 515 US 557 574 1995. And then the footnote 9 says the majority argues this concern about deepfakes is overblown because a person's voice can also be captured through an unannounced recording. This misses the critical point. Once a person has noticed that her conversation will be recorded, she can choose not only what to say, but also whether to speak at all. Okay. As the Supreme Court has explained, the First Amendment securely protects the freedom to make or decline to make one's own speech. It bears less heavily when speakers assert the right to make other people's speeches. Eldred versus Ashcroft, 537 U.S. 186221, 2003, emphasis added, rejecting a First Amendment challenge to a copyright extension. See also Harper and Row Publishers, Inc. versus Nation Enters, 471 U.S. 539 559, 1985, recognizing, along with the freedom to express one's views publicly, the concomitant freedom not to speak publicly. Quoting State of Hemingway versus Random House Inc. 244 Northeast NE 2D 250 255 New York 1968. Project Veritas stresses that it clandestinely recorded conversations that will be held mostly in public places like cafes or parks. But the state has a significant interest in preventing the secret recording of private conversations, even when those conversations occur in public or semi-public locations. Everyday experiences tell us that private talk in public places is common. Alvarez, 679 F3D at 606, citation omitted. In many circumstances, even if a conversation may be heard or overheard by multiple people, the state maintains a significant interest in preventing its recording. For example, the state of Oregon points out that this interest is most obviously in multi-party gatherings that welcome members of the public, yet expect that attendees will not make secret recordings of each other, such as 12-step groups, Bible study, and religious services. Well, our society respects those boundaries. Oregon has a significant interest in preventing unannounced recordings of oral in-person conversations. The next question is whether Section 165.5401C is narrowly tailored to that interest. I conclude it is. By requiring that participants in conversation be informed before it is recorded, but not requiring that they consent to the recording, the statute infringes as little as possible on the process Project Veritas intends to use to create its speech, while still protecting the interviewee's right to knowingly participate in Project Veritas' speech or not. Once a person is on notice that she will be recording does not violate any privacy interest. Keeping the Oregon legislature's actual purpose in mind, the statute is exceptionally well tailored to ensuring that Oregonians' conversations will not be recorded without their knowledge. Consistent with that interest, the statute does not sweep in photography or video recordings, but rather applies only to the recording of oral communications. Footnote 10. Although private talk in public places is common, Alvarez 679 F3D at 606 citation omitted, and many people may reasonably expect, even in public places, that their private conversations will not be recorded. A person cannot reasonably expect that his visual image will not be captured in public, okay? So there are some settings to which people cannot reasonably expect not to have their oral statements recorded, and the Oregon legislature crafted its statute to account for those situations. The prohibitions in subsection 1C of this section do not apply to persons who intercept or attempt to intercept oral communications that are part of any of the following proceedings if the person uses an unconcealed recording device. Public or this is section 8. Public or semi-public meetings such as hearings before governmental or quasi-governmental bodies, trials, press conferences, public speeches, rallies, and sporting or other events. B, regularly scheduled classes or similar educational activities in public or private institutions. Or C, private meetings or conferences if all others involved knew or reasonably should have known that the recording was being made. Oregon Revised Statute 165.5406A. The exceptions in Section 165.5406A permit Project Veritas to openly record at public protests as it proposes to do. Project Veritas points out that this exception does not render Section 141C perfectly tailored to Oregon's stated purpose. For example, the law prohibits recording a loud argument on the street, a political provocateur on a crowded subway, or a drunk, hate-filled conversation in a parking lot, even though the participants in such a conversation lack any expectation that their words will not be recorded. Section 165.5401C's notice requirement may be overbroad as applied to these fringe cases, but far from demonstrating that a substantial portion of the burden on speech does not serve to advance Oregon's goals. Ward 491 U.S. at 799. Project Veritas's resort to these niche examples illustrates that the bulk of Oregon's protection against secret audio recording is targeted at achieving the state's significant interest. Nothing more is required to meet intermediate scrutiny's tailoring requirement. Page 61. Section 165.5401C also leaves open ample alternative channels of communication for Project Veritas to engage in investigative journalism and to communicate its message. It is well settled that an alternative channel need not be ideal, but merely adequate. See Heffron versus International Society for Krishna Consciousness, Inc., 452 U.S. 640, 647, 1981. Reynolds v. Middleton, 779 F3D 222, 232, and 3 and 5, 4th Circuit 2015. The available alternatives need not be the speaker's first or best choice or provide the same audience or impact for the speech. Citation and internal quotation marks omitted. Weinberg versus City of Chicago, 310 F3D 1029, 1041, 4th Circuit 2002. An adequate alternative does not have to be the speaker's first channel choice. A restriction runs afoul of the alternative channels requirement if it eliminates the only method of communication by which speakers can convey their message to a particular audience. CEG Bay Area Peace Navy versus United States 914 F2D 1224, 1229 to 30, 9th Circuit, 1990. But a regulation does not fail intermediate scrutiny merely because the other available channels of communication would convey the same message somewhat less conveniently or effectively. CEG Santa Monica Nativity Scenes Communication versus City of Santa Monica, 784 F3D 1286, 1298 to 99, 9th Circuit, 2015. One World Family Now or Fam Now versus City and County of Honolulu, 76 F3D 1009, 1014, 9th Circuit, 1996. We have observed that the Supreme Court generally will not strike down a governmental action for failure to leave open ample alternative channels of communication unless the government enactment will foreclose an entire medium of public expression across the landscape of a particular community or setting. Minati v. City of Seattle, 409 F3D 1113, 1138, 9th Circuit, 2005. Alteration accepted. Internal quotation marks and citation omitted. Project Veritas has no colorable argument that it would be unable to gather information to engage in investigative journalism, to communicate its message across the landscape of a particular community or setting, or to reach a particular audience if it cannot secretly record in-person oral interviews. Indeed, we made clear in Chapman that restricting surreptitious recording does not foreclose an entire medium. For 449 F2D at 249. Project Veritas retains ample alternative means of engaging in investigative journalism and expressing its message. It can employ all the tools of traditional investigative reporting, including but not limited to talking with whistleblowers and other inside sources, crowdsourcing information, researching public records, taking photographs and recording videos that do not capture oral conversations, and using Oregon's Freedom of Information law. Don't make me laugh. CEG, Oregon Revised Statute 192.311, 431, 192.610, 69.695. It can also openly record during public and semi-public meetings and events. Oregon Revised Statute 165.540.6AA. And in other settings, provide notice that it is recording without announcing that it is engaging in investigative journalism. Here's the footnote 11. The majority protests that Dietman addressed whether the First Amendment bars state tort liability for invasion of privacy, but my colleagues do not try to explain why Dietman's observation about the nature and history of investigative reporting are not applicable here. These many approaches to traditional investigative reporting satisfy the alternative channels requirement. Okay, 3. Rather than taking the straightforward path that the case calls for, the majority strikes down all of section 165.5401C by making several unjustified leaps. First, the majority decides that the two content-based exceptions Project Veritas challenges cannot be severed because it reasons the exceptions themselves are not unconstitutional, and severing them would raise other constitutional questions. Despite strong indications to the contrary, the majority next decides that the Oregon legislature would rather strike down the state's entire statutory protection for conversational privacy rather than sever the two exceptions. The majority also errs by invoking case law that addresses statutes and ordinances adopted to protect others from unwanted commercial or political speech. Finally, my colleagues conclude that even if the two exceptions are severed, section conclude that even if the two exceptions were severed, section 165.5401C would still be unconstitutional because it fails to leave open ample alternative channels of communication. The majority makes several missteps in its analysis. A, I agree that section 165.5401C would not survive strict scrutiny viewed as a whole. Indeed, Oregon never argues otherwise. But the state of Oregon specifically describes Oregon's interest in the statute as protecting Oregons from having their private conversations unwittingly made the subject of audio recordings without their knowledge. See NEF 265 P3D as 66. The primary concern underlying section 165.5401C was the protection of participants in conversations from being recorded without their knowledge. The majority redefines Oregon's interest, reasoning because of the act of recording a conversation is protected speech. Oregon's interest is more accurately stated as protecting individuals' conversational privacy from the speech of other individuals, even in places open to the public. Slip up at 25. The analogy the majority draws to case law addressing statutes protecting individuals from the unwanted speech of others is flawed. See Cohen v. California 403 U.S. 1521 1971, Hill of Colorado 530 U.S. 703 717 2000, Berger versus City of Seattle 569 F3D 1029 1054 9th Circuit 2009 en banc, Cuba v. 1A Agricultural Association 387 F3D 85861 and 10 9th Circuit 2004. The cases the majority cites involve restrictions on speech intended to further different interests, such as preventing the display of profane slogans in a courtroom, Cohen, limiting abortion protesters' unwanted approaches toward clinic patients, Hill, shielding parkgoers from obnoxious behavior by street performers, Berger, and protecting commercial patrons from the speech of protesters, Cuba. None of the cases cited by the majority address one speaker's appropriation of another person's speech, as Project Veritas proposes to do. Our court gravely missteps by ignoring that this appeal implicates not only the First Amendment rights of the person creating a recording, but also the First Amendment rights of those who do not wish to have their speech recorded. The majority incorrectly asserts that Wasden forecloses my analysis. Slip up at 28. Wasden concerned a video of cows being abused at an agricultural facility, not a secretly recorded audio conversation between people. C878 F3D at 1189 to 90. Wasden cannot bear the weight of the majority places on it because the video in that case did not require the court to confront a secret audio recording that invaded conversational privacy and captured the oral communications of other people. The majority is also incorrect to suggest that Wasden foreclosed any argument that unannounced recordings that appropriate other speech place a greater burden on privacy than other types of unwanted expressive conduct. Wasden held that the creation of a recording is speech protected by the First Amendment. See it at 1203. It did not purport to address whether the invasion of privacy caused by secret recording of private conversations is equivalent to the invasion of privacy caused by being bombarded with unwanted speech in public places. B, the majority agrees that Oregon law governs severability, but it concludes that the dangerous felony and law enforcement exceptions cannot be severed from section 165.5401C for three wobbly reasons. First, the majority decides that even without these exceptions, the statute would be unconstitutional because it fails to leave open ample alternative channels. I disagree with this conclusion for reasons previously explained and because my colleague's rationale contravenes our own court's recognition that investigative journalism does not require secret recording devices or hidden cameras. See Dietman 449 F2D at 249. The majority also argues that Oregon law does not permit the two challenged exceptions to be severed because the exceptions themselves are not unconstitutional. The majority misreads Oregon law, in particular its reliance on State v. Dilts 103 P3D 95, Oregon 2004 is sorely misplaced. There, a defendant's Sixth Amendment rights were violated when a judge imposed a sentence above the state law guidelines without providing the defendant an opportunity to argue the facts justifying an increased sentence to the jury. At 99. On appeal, the prosecution asked the court to sever the state law requirement that the defendant's sentence be within the guidelines, even though neither party had challenged the constitutionality of the mandatory guidelines. ID. In other words, the prosecution asked the court to sever the requirement not because it rendered the statute unconstitutional, but because it rendered the defendant's sentence unconstitutional. It was only in response to the prosecution's unusual argument that the Oregon Supreme Court explained it would not sever a statute that neither party claimed was unconstitutional. The Oregon Supreme Court makes no bright line distinction between exceptions that are themselves unconstitutional and exceptions that render the remainder of the statute unconstitutional. For instance, in outdoor media dimensions, the Oregon Supreme Court evaluated a multifaceted state statute that regulated highway signs, 132P3D at 7. The plaintiffs challenged several of the statute's provisions, including one that required permits for highway signs unrelated to the premises, but exempted on-premises signs, it at 9. The permit requirement and exception were adopted at the same time. See Oregon Revised Statutes 377.725, 377.735, 1971. The court concluded that the on-premises exemption was content-based and that it rendered the permitting requirement unconstitutional, but it upheld the rest of the statute. Outdoor media dimensions 132 P3D and 19. Notably, the court did not consider the constitutionality of the exemption, which allowed on-premises signs without permits in isolation. Rather, the court concluded that the on-premises, off-premises distinction was unconstitutional and that severance of that provision was appropriate. It also, City University versus State of Office of Education, POLY, and Plan 885 P2D 701, 703, 706 to 7, or 1994. Page 67. Severing an exception that caused an Oregon statute to discriminate against out-of-state schools in violation of the Commerce Clause. Turning to the remedy, the Outdoor Media Dimensions Court considered the same two unpalatable choices that the legislature would face, namely whether to strike only the exemption from the permitting requirement and require permits for thousands of individuals and businesses, or to instead strike the permitting requirement entirely, 132 P3D at 19. The court decided the outcome should turn on legislative intent alone and ultimately invalidated the entire permitting requirement because it concluded that the legislature would not have enacted it without the simultaneously enacted exemption. In hereby contrast, I see no viable argument that the Oregon legislature did not intend the dangerous felony exception and the law enforcement exception to be severable because Section 165-5401C was operative for decades before these exceptions were added. CAAPC 140 S Court at 2353. The legislature did not direct the exceptions may not be severed. They are not interconnected, nor is the remaining part of the statute incomplete or inoperable without them. Oregon Revised Statute 165.540. Finally, the majority argues that Oregon courts would invalidate all of Section 165.5401C, not just the content-based exceptions, because severing those exceptions would raise other constitutional concerns. Footnote 12 goes, the majority also relies on the legislative history of the challenged exceptions, taking the unusual step of calling out statements made by the Oregon State Sheriff's Association and the ACLU to divine legislative intent, up at 9 to 10. To support this contention, the majority states State versus Borowski 220 P3D 100-109, Oregon Court of Appeals 2009, which considered, among other factors, the legislature's preference to avoid enacting bills that raise serious questions of constitutionality. But Borowski, much like Outdoor Media Dimensions, concerned an exception enacted simultaneously with the challenged provisions. See it at 109, Oregon Revised Statute 164.887, 1999. Because the Oregon legislature enacted Section 165.541C as a standalone provision that operated for decades before it adopted either of the challenge exceptions, we are not left to wonder whether the legislature would enact Section 165.540 on its own. It did exactly that in 1959. See State X Rel Musa v. Minier 401 P2D 3639, Oregon 1965, declaring an amended state statute invalid and reverting to the pre-amendment statute. Failing to sever the two exceptions makes even less sense when one considers that the majority concedes the First Amendment. Hey, I'm busy. We'll talk later after 1. Failing to sever the two exceptions makes even less sense when one considers that the majority concedes the First Amendment protects the right to record law enforcement officers in public and the right to make unannounced recordings during felonies that endanger human life. See Askins 899 F3D at 1044, Obsidian Fin Group LLC versus Cox 740 F3D 1284, 1291 to 92, 9th Circuit 2014, Fortitude versus City of Seattle 55 F3D 436, 439, 9th Circuit, 1995. Footnote 13. Other circuits agree. On recording law enforcement officers, see, for example, Glick versus Knief, 655 F3D 7885, First Circuit, 2011, Fields versus City of Philadelphia, 862 F3D 353, 359, Third Circuit, 2017, Turner versus Lieutenant Driver, 848 F3D 678, 688, Fifth Circuit, 2017, Alvarez 679 F3D 583, Smith versus City of Cumming 212 F3D 1332, 1333, 11th Circuit 2000. Indeed, the First Circuit has held that the First Amendment right to record law enforcement is clearly established even for the purpose of qualified immunity. See Glick 655 F3D at 85. A citizen's right to film government officials, including law enforcement officers, in the discharge of their duties in a public space is a basic, vital, and well-established liberty safeguarded by the First Amendment. On recording crimes, see, for instance, Adventure Outdoors, Inc. versus Bloomberg 552 F3D 1290, 1298, 11th Circuit 2008, observing that speech that alleged violations of federal gun laws involved a matter of public concern. Boole versus Hutton 328 F3D 8491, 2nd Circuit 2003, holding that an article addressing art market fraud is certainly protected under the First Amendment. Okay. So here we go right back up to where I got lost on that big long footnote. Okay, so we're on page 69. Because the exceptions to section 141C permit conduct protected by the federal constitution, but the exemptions could be struck without changing the speech that is permitted in Oregon. C.F. Alvarez 679 F3D at 608, enjoining Illinois from enforcing its recording prohibition as applied to open audio recording of law enforcement officers engaged in their official duties in public places. And nevertheless, the majority concludes that because Oregon's legislature included these carve-outs, Oregon's entire notice requirement must receive strict scrutiny. The majority's reasoning places the legislature in a catch-22. The First Amendment requires it to carve out the two challenged exceptions, but because the legislature included the carve-outs, the majority decides the entire statute becomes subject to strict scrutiny. We need not adopt this topsy-turvy approach. We should simply sever the two challenged exceptions. Perhaps the weakest link in the majority's opinion is its conclusion that section 165.5401C does not leave open ample alternative channels of communication because it constitutes an absolute prohibition on a particular type of expression, namely unannounced audiovisual recordings. Setting aside that the statute does not address video recording, I disagree that Oregon's ban on unannounced audio recordings eliminates the entire medium of public expression. And there is a citation to see Oregon Revised Statute 165.5351. The majority cites Landmark Associations, Inc. versus Township of Willingboro 431 U.S. 85 to 93, 1977, City of Ladue versus Gileo 512 U.S. 43, 56 to 57, 1994, McCullen versus Coakley 573 U.S. 464, 487 to 90, 2014. United BHD of Carpenters, Brotherhood of Carpenters and Joiners of AM Local 586 versus NLRB, National Labor Relations Board, 540 F3D 957 969, 9th Circuit 2008, and Foti versus City of Menlo Park 146 F3D 629 635, 9th Circuit 1998, in support of the alternative channels holding, but these cases all miss the mark. In Landmark, the Supreme Court invalidated as content-based a township's ban on for sale signs, which it had enacted to stem what it perceived as the flight of white homeowners from a racially integrated community. .431 U.S. at 86. The court stressed that the township council was concerned with the substance of the information communicated by the signs and that the ban was not unrelated to the suppression of free expression. It at 93, 96, quoting United States versus O'Brien 391, U.S. 367, 377, 1968. Landmark's language cannot be stretched to imply that any alternative that is less effective than the speaker's chosen medium is far from satisfactory. Slip up at 35, quoting Landmark 431 U.S. at 93. Rather, Landmark explained that the court doubted whether the ordinance left open ample alternative channels for communication because the alternatives were less effective, and also because these alternatives involved more cost and less autonomy than for sale signs, and were less likely to reach persons not deliberately seeking sales information. Landmark 431 U.S. at 93, internal citation submitted. After Landmark, the Supreme Court clarified that an alternative need not be a speaker's first or best choice, but it is adequate if it permits the more general dissemination of a message. Frisbee v. Schultz, 787 U.S. 474, 483, 1988. C. Heffron, 452 U.S. at 647. The First Amendment does not guarantee a the right to communicate one's views at all times, page 71, and places in any manner that may be desired. Project Veritas does not argue that alternatives to surreptitious recording involve more cost or less autonomy, or otherwise make their message less likely to reach its intended audience. Project Veritas's complaint is that Oregon statute will impede its ability to gather information. City of Ladue also failed to support Project Veritas's cause. Therefore, the Supreme Court held that a restriction on residential signs did not leave open adequate alternative channels of communication, because displaying a sign from one's own residence often carries a message quite distinct from placing the same sign someplace else or conveying the same text or picture by other means. 512 U.S. at 56. City of Ladue emphasized the long-held tradition of respect for individual liberty in the home and for a person's ability to speak there, it at 58. Here, by contrast, Project Veritas does not argue that reporting an in-person oral conversations without surreptitiously obtained audio recordings would convey a different message, only that its information gathering would be somewhat less effective, and therefore is no comparable tradition of respect for surreptitious recording. Indeed, surreptitious recording is generally considered a breach of journalistic ethics, except when certain narrow criteria are met. McCullen is even less applicable. There, the court struck down a statute establishing buffer zones around abortion clinics because the statute was insufficiently tailored. Okay, we'll hit footnote 15, CEG, Radio, Television, Digital News Association, RTDNA guidelines for hidden cameras. Okay, hidden cameras, okay. The court did not even reach whether the act leaves open ample alternative channels of communication, McCullen 573 U.S. at 496, number 9. The majority correctly observes that the First Amendment's protections extend to the right to choose a particular means or avenue of speech in lieu of other avenues. United Brotherhood 440, F3D at 969, quoting FOTI 146, F3D at 641. But Section 165, 541C governs how, not whether, Project Veritas can use recording devices. The statute thus permissibly regulates the manner of speech in a content-neutral way without infringing on the individual's right to select the means of speech. 146 F3D at 64142. The majority of Project Veritas both argue that recordings are unique in their trustworthiness, self-authenticating character, and ease of distribution, ignoring that surreptitious audio recording is a uniquely effective means for reporters to gather information precisely because it is uniquely effective at invading privacy. The very aspects of surreptitious audio recordings that render it distinct from other modes of communication, such as discreteness and its ability to widely disseminate the contents of a conversation, are the same aspects that render it particularly damaging to privacy. Footnote 16, it is also worth noting that the self-authenticating character of audio recordings is rapidly eroding as modern technology renders deepfakes ever more accessible and difficult to distinguish from actual recordings. See generally Bobby Chesney and Daniel Citron, Deepfakes, a looming challenge for privacy, democracy, and national security, 107 Cal, L Review 1753, 1755 to 68, 2019. The majority's alternative channels analysis is particularly concerning because it has no obvious limits. My colleagues suggest that their opinion will be cabined because they view Section 165.5401C as an outlier among other did they say outlier? Among other states' limitations on recording conversations. But if it is enough to show that newsworthy information could be obtained by a particular method, the majority's rationale might well apply to Oregon's eavesdropping statute or to narrow conversation privacy statutes adopted in other states. After all, eavesdropping and unannounced recording in non-public locations are also effective methods to gather information of public concern that cannot be otherwise obtained. Though the majority disavows the suggestion that its reasoning could be applied to strike down eavesdropping statutes, it is hard to see whether 40 other states that have adopted more limited conversational privacy statutes are not vulnerable in light of today's opinions. Generally applicable laws do not offend the First Amendment simply because the enforcement against the press has incidental effects on its ability to gather and report the news. Cohen versus Cowles Media, Co. 501 U.S. 663, 669, 1991. In this case, we would simply sever the constitutionally suspect exceptions that Project Veritas challenges and uphold the remainder of Section 165.5401C. Appendix D. Oh, Appendix A. So yay, finally I'm to the end of That's the dissent. Wow, thrilling, isn't that? And then the appendix, I am not going to read that for you, although I assume there's somebody that law nerdy that wants that whole thing read out. For disability access is a huge thing for doing an audio version of this. For me, it helps me pay attention and absorb the language. Okay, I guess I'm kind of disappointed it's all over. Am I? Okay, so we're at page 60. So basically, just kind of looking over it quickly, she puts as her appendix A, states allowing recording without providing notice to or obtaining consent from the recording subjects when created in a place where the subjects lack a reasonable expectation of privacy. So it's basically a big pile up of appendix of like citations: Alabama, Arizona, Arkansas, California, Colorado, Connecticut, Delaware, DC, Florida, Georgia, Hawaii, Idaho, Illinois, Iowa, Kansas, Louisiana, Maine, Maryland, Michigan, Minnesota, Mississippi. Oh my gosh, Nebraska, Nevada, New Hampshire, New Jersey, North Carolina, North Dakota, Ohio, Pennsylvania, Rhode Island, South Carolina, South Dakota, Tennessee, Texas, Utah, Virginia, Washington, West Virginia, Wisconsin, Miami. States prohibiting recording without providing notice to or obtaining consent from the recording subjects when created in a place where the subjects lack a reasonable expectation of privacy: Alaska, Kentucky, Massachusetts, Montana. States without laws regarding the recording of in-person conversations: Indiana, Missouri, New Mexico, New York, Vermont. Hey, what's up with that? That's worth checking out, guys. Okay, hope you enjoyed that.